Welcome to a new session today, and that's about which we always do weekly. That's about polity and governance for the week. Let's track what are the important topics for polity and governance for the week gone by, and let's start up with the most important issue, and that is about the implementation of the citizenship amendment rules that the government has decided to implement. But then there are a slew of petitions in the Supreme Court calling for the stay for the implementation of the Citizenship Amendment Act. And it was just a few days before the announcement of the Lok Sabha elections that the Citizenship Amendment Act was come into force by the Ministry of Home Affairs. Now, let me tell you that this act gives citizenship to the persecuted minorities from three countries, that's Bangladesh, Afghanistan and Pakistan. And the minorities from these countries include the Hindus, the Sikhs, the Parsis, the Buddhists, the Jains, except for the Muslims. However, this Citizenship Amendment Act is being criticized as it violates the Article 14 and also violates the provisions of the Constitution, where it provides citizenship based on religion, which is not in tune with the Citizenship Act and also the Constitution, which provides citizenship for the people in the country, or other ways of getting citizenship through naturalization and registration. There is no provision for citizenship based on religion. Also, there are some other important issues with regard to this. The timing of the imposition of the rules have been criticized. It is saying that it is said that the rules have been come into force just before the elections, and so a lot of illegal migrants who've come away from Pakistan, Bangladesh and Afghanistan are bound to get citizenship, and they will be eligible to vote, therefore giving the ruling party advantage of these votes that it will get because of imposing of the Citizenship Act. Otherwise, usually people who come to India as illegal migrants are either deported and sent back if they do not have proper documentation. But this provision has been brought to provide citizenship to a few minority communities from these three countries who have been persecuted there. And now there have petitions in the Supreme Court challenging the implementation of this. So let me tell you that the court has decided to consider the matter arising from Assam, where also the exercise of the National Register for Citizen has taken place. And the Supreme Court, however, declined to restrain the centre from granting citizenship to the non-Muslims from Pakistan, Bangladesh and Afghanistan under the Citizenship Amendment Act. As many as 237 petitions are filed before the court challenging the validity of the Citizenship Amendment Act of 2019. The petitions have claimed that the Citizenship Amendment Act discriminates against the Muslims community. It has been argued that there is a religious segregation and it is unreasonable and also infringes the Article 14 of right to equality. Now, the Indian Union Muslim League is a primary petitioner in the lead case, which has filed almost 137 separate petitions challenging and the legality of the CAA on the ground that it discriminates on granting of citizenship on the basis of religion. The rules have done away with the independent and tired scrutiny of applications of citizenship by the district collectors on the ground and recommendations of the state government as to the wisdom for granting of citizenship to the applicants. Even that also has been done away. The citizenship rules have required the centre to actually consult the state government before granting of citizenship, and these rules which have been enforced now does away with this. The scrutiny of the application for registration for naturalization was held on three levels, that's the collector, the state government and the central government, and now ultimately it is only the central government that has given itself the decision to grant citizenship, and this is one of the other criticisms as well. So this is a legislation which is based on exclusion of religion and it strikes the concept of secularism. So these are the points on which there has been criticism with regard to the Citizenship Amendment Act. Now, something very much related to this is a very first time that the Muslim women have carried out a movement with regard to the in criticism of the Citizenship Amendment Act, and that's about the Shaheen Bagh movement. So it challenged, it all changed on one cold bitter night in December in Delhi when the news came of police atrocities on the Jamia Millia Islamia students protesting against the CAA CAA in the vicinity, and soon we could see women of the Shaheen Bagh living around a kilometer of Jamia were galvanized into action. The CAA was opposed peacefully, persistently, and to the surprise of everybody, not only young people but also elderly women of Shaheen Bagh who were in the 70s and 80s also never stopped, and who never stepped out of their homes, came in support of criticizing the CAA and calling for a stay on the implementation of the Citizenship Amendment Act at that very time, and it was their protest which actually led to the delay of the implementation of the Citizenship Amendment Act, and it is called one of the most successful movements in the post-independence period by the Muslim women. They held the constitution in one hand and also the Quran to assert the status as equal citizens of this land, and they demanded for protection of their citizenship rights. So the Shaheen Bagh protest became a movement which not only spread across the country but also got a lot of international attention. The dadis or the grandmothers of the Shaheen Bagh made it to the Time magazine, and reams began to be written on determined struggle of the Shaheen Bagh women against the CAA, which allows the religious minorities of Pakistan, Afghanistan and Bangladesh to get citizenship in India. Among the first books that were written about Shaheen Bagh were Shaheen Bagh and the Idea of India, edited by veteran journalist Seema Mustafa and published by Speaking Tiger, and Shaheen Bagh from a protest to a movement, published by Bloomsbury, and theirs was probably the first Muslim women-led movement since independence. They had not come out on the streets to protest against Shah Bano previously like this, or even the Babri Masjid demolition, but they kept their counsel, and they even did not protest against the triple talaq. But however, they fought for Article 14 of the Constitution, sitting under the open skies in Delhi, and every day began with a rendition of the Sare Jahan Se Acha, and every midnight closed for them with Jana Gana Mana. And this was the protest which led to a revolution, which with the hijab-clad women of Shaheen Bagh became revolutionaries who stopped the implementation of the CAA until now. And it was just 2 days before the pronouncement of the election schedule that the Citizenship Amendment Act came into force, and it was announced by the Home Minister, and now pleas are being filed in the Supreme Court against the implementation and calling for a stay for the implementation of the CAA rules. So the next most important issue is with regard to a fact-checking unit, and even this also is being formed just before the elections. It is being criticized as a way to clamp down on free speech, especially during the time of elections. So the Information Technology Guidelines and Digital Media Ethics Code rules of 2021 were issued by the Centre to deal with fake news against the government and to bring down such content from the social media platforms by a unit called as a fact-checking unit. Now the Supreme Court stayed the government notification of forming a fact-checking unit and establishing the Press Information Bureau's fact-checking unit to act as a deterrent against the creation and dissemination of fake news and misinformation regarding the business of the Centre. The Supreme Court flagged how it was important because it would crack down on free speech and expression. That's what that is a criticism against the fact-checking unit. The order was passed by a 3-judge bench headed by R.D.Y. Chandrachud, that is our very own Chief Justice of India, and the pleas were filed by Editors Guild of India and also one stand-up comedian, Kunal Kamra. Now the bench said that it would stay until the bench said the implementation of this fact-checking unit would remain stayed until a 3rd judge of the Bombay High Court took a final decision on the validity of these rules under the Information Technology rules of 2021. Now under the IT rules, if the fact-checking unit comes against any information about any post or which are fake or false, or they contain misleading facts about the business of the government, then it could flag the same to the social media intermediaries, and the social media intermediaries have to remove them immediately from their platforms. Now the petitioner contended that the establishment of the FCU would result in every social media intermediary pulling down content for the fear of consequences, and this will have a deep chilling effect on free speech. Now the Centre setting up a free fact-checking unit to protect the business of the Centre was like Caesar judging the Caesar, and the Centre had assured the High Court on April 27th last year that that it would not implement Rule 3 till a final decision was taken by the court, and the issuance of this March 28th notification barely before the Lok Sabha polls were due to start is seen as a violation of what it said. Now, the FCO run by government would ensure that the center would have the monopoly over the truth, and by threatening the intermediaries that they would lose the statutory safeguard if they fail to take down the information, this would actually coerce the social media intermediaries to take out whatever information that the government asked them to do. It's another way cracking down on free speech or freedom of expression, and this is what is said. So the Press Information Bureau had been at the forefront till now to take proactive measures to deal with fake news related to the government of India, and in November 2019, the Press Information Bureau fact-checking unit with the purpose of tackling the issues of fake news pertaining to the government of India and its various ministries, departments, public sector undertakings and other central government organizations was formed. Let me tell you, it is headed by a senior DG and ADG level of the Indian Information Service, and the day-to-day operations are operated by various officers of the service at various levels. So the other most important thing again with regard to judiciary is that should judges accept political posts after retirement, or should they join politics after being in the judiciary, and how far this is ethical. So this has been a controversy which rose because the High Court, the judge of the High Court, Calcutta High Court, resigned from the judiciary to enter into politics, raising significant ethical concerns about the judicial impartiality, independence, conflict of interest, public trust, and also professional responsibility. Now, there are many dimensions to the ethical side of this, how far it's right. These concerns have far-reaching implications for the integrity, credibility of the judiciary, highlighting the importance of upholding ethical standards in the administration of justice. Now, recently, the former Calcutta High Court judge had resigned and joined a political party, sparking a controversy by the move of the judge, and concerns were raised about the judge's resignation from the judiciary to join active politics, because this is the executive and that's the judiciary, which will have significant ethical implications that will affect the perception of the judicial propriety, impartiality, and also integrity of the judiciary. Let me tell you, this is not the first time. In 1967, the former Chief Justice of India, K. Subbarao, resigned 3 months before he was to retire to contest the presidential election, and Supreme Court Justice Baharul Islam had resigned 6 weeks before the retirement in 1983 to contest the Lok Sabha poll. So what exactly are the ethical concerns? So first is judicial impartiality. Judges are expected to remain neutral and not take any sides, and also make decisions solely on the basis of fact and laws without being influenced by personal biases, favoritism, or even external pressures. The sitting judge's decision to join a political party definitely will raise question about its the judge's previous judgments, or his or her participation in the cases involving the political parties of which he is a part now. Judicial independence. Judicial independence is very crucial for maintaining the rule of law and democracy. Judges must be free from independence and influence of outside parties, especially political parties, and the decision of a judge to align himself with the political party shortly after his resignation and retirement calls for question on independence of his previous judicial decisions. Conflict of interest is the third one. Judges are expected to avoid conflict of interest and maintain the integrity of judicial process. His involvement in the political party, particularly after making controversial statements and rulings while in the bench, raises concerns about is potential conflict of interest. And the next one is public trust and confidence. So the judiciary relies on public trust and confidence to fulfill its role in the society. When judges engage in actions that undermine the perception of judicial integrity and impartiality, it erodes the public trust and also entire judicial system. And issue of post-retirement appointments. So over the years, some judges have accepted government posts after retirement, and this practice blurs the clear demarcation between the judiciary and the executive. And we also have the ethical principles or the standards that have to be followed by the judges, where it is said that they have to be independent, impartial, and not take sides of political parties, and also not join any political party even after retirement. Also, this is in the restatement of values of judicial life in 1997, that every judge takes an oath of before practicing, and this definitely this will be violated once the judge also tries to enter into politics. The next most important issue is about Supreme Court now dismissing the pleas to stay the appointment of the poll commissioners. So the Supreme Court dismissed the application seeking a stay on the appointment of the recent election commissioners Sukhbir Singh, Sandhu and Gyaneshwar Kumar as election commissioners in accordance with the new law giving effect to their role, and it questioned the selection process of the government. Now the applications have been filed by one NGO, Association for Democratic Reforms, and others have urged the government to stay the implementation of the Chief Election Commissioner and other election commissioners Act of 2023, which forms a search committee and the selection committee to appoint the Chief Election Commissioner and the other election commissioners of India. The applicants had asked for fresh appointments to the posts of the two election commissioners on the basis of the Supreme Court judgment that had been given earlier, where the Chief Justice of India forms a part of the selection committee along with the Prime Minister and the leader of the opposition. Now the Chief Justice of India has been replaced by a minister appointed or chosen by the cabinet. Now the applicants have asked for fresh appointments to these two offices on the basis of the selection committee composition given by the Supreme Court judgment. However, the judge said that we cannot stay the legislation and this will lead to a lot of chaos, pointing out that the Lok Sabha elections have already at the doorstep and it was ready to commence from April 19. Now, advocates for the NGO argued that the selection of the election commissioners cannot be left totally in the hands of the central government, where the majority will always be favorable to the executive, that is seeing the composition of the selection committee. This is against free and fair elections. This is what the advocate for the NGO argued, but then the judge went on to say that there was no allegations against the two appointees, that is Sandhu and Kumar, and the judgment was just a stopgap arrangement until the Parliament brought out a law for the appointment of the Election Commission, and the Supreme Court cannot force the government to do something or take back a legislation after once it is brought into force. So let me tell you that the bench was critical about the manner in which the details of the candidates were given to Adil Ranjan Chaudhary, who is the leader of the largest opposition party and a member of a high-level selection committee, just mere hours before deciding on the name. The judge went on to say that they could have been transparent and given more time to scan 200 profiles, and and therefore they were critical of this step of the government. The two ECs, let me tell you, were appointed on March 14th and they took charge on March 15th, and the election schedule was announced on March 16th. And the government said that all the profiles of the eligible persons were shared with Chaudhary, but the manner in which the time limit was given was not right or apt. And the government said that the 2023 law was just a step to implement one of the clause of the Article 324, which says that that the appointments of the Chief Election Commissioner and other election commissioners will be done with the President in the manner by a law made by the Parliament. We did not have a law till now, and now we have a law for the appointment of the CEC and the ECs, which has a search and a selection committee as well. And the next most important issue is with regard again to High Court saying that the UP Madrasa Education Act is unconstitutional. So the Allahabad High Court declared the UP Board Madrasa Education Act of 2024 unconstitutional, saying that it violates the principle of secularism as well as the fundamental rights provided under Article 14 of the Indian Constitution. Now, 2004 law by the Uttar Pradesh allowed the state government to establish a board which is called as the Uttar Pradesh Board of Madrasa Education, which is empowered to impart education from primary level to postgraduate and also research levels. Since there are a large number of madrasas and madrasa students in UP, the bench has directed the state government to take steps to accommodate these steps into the recognized schools. And the court was hearing a petition filed by one UP advocate challenging the 2004 law on the ground that it violated the principles of secularism, which is a part of the basic structure of the Constitution, as well as Article 14 and 15 and 21A of the Constitution. A single judge bench of the High Court also raised the questions over the validity of the law way back in 2019, and it asked for the questions to be referred to a larger bench. The petitions also pertain to the payments of salaries to the madrasas teachers. In the judgment now, the court asserted that the education being imparted by madrasas is neither quality nor even universal in nature, referring to the subjects being taught in the madrasa board. It also further asserted that the state has no power to form a board for religious education or establish a board for school education for any particular religion, and this is against the principles of secularism. The next most important issue is Tamil Nadu governor now going Tamil Nadu government going against the Tamil Nadu governor to Supreme Court, and the Tamil Nadu governor R.N. Ravi is once again come under the radar of the Supreme Court for refusing to re-induct a DMK MLA Ponmudi in the state cabinet, despite the top court saying that his conviction was in the corruption case was stayed. Now the Supreme Court went on to say that when the Supreme Court itself stayed the conviction of the MLA, the governor has no business to tell the government what to do or to what this does. The governor does not have any business to question the appointment of the same person as a minister. And the 3-judge bench led by Chandrachud remarked that the governor's refusal to reappoint Ponmudi defied the top court's order. Supreme Court stayed Ponmudi's conviction on the disproportionate assets case. Following his conviction by the Madras High Court, Ponmudi has actually lost his membership to the state legislative assembly. Therefore, when his conviction was stayed, Stalin wrote to Governor R.N. Ravi recommending his re-induction into the Council of Ministers. On March 17, the governor wrote to the Chief Minister that since Ponmudi's conviction was stayed and was set aside, he should be inducted to the state cabinet, which would be a constitutional morality. And let me tell you, it is not the governor's prerogative to decide who should be inducted and not. The governor has to function on the advice of the CM, and the conviction of Ponmudi was stayed, and the governor has to accept the advice of the Chief Minister to induct the MLA as a minister. Days after the Supreme Court made the strong observations, Tamil Nadu governor then R.N. Ravi went on to re-induct Ponmudi by administering him the oath of office and secrecy in presence of Chief Minister Stalin in a ceremony. Now, the state argued that the governor has no individual discretion in appointment of the ministers, and he is bound by the advice of the Chief Minister along with the Council of Ministers, and the candidate that is selected by the Chief Minister has to be appointed as a minister whether the governor likes it or not. So the governor has to function according to the aid and advice of the Chief Minister. This is specified under Article 164(1) of the Constitution. And the next most important issue is with regard to Arvind Kejriwal sending to custody till March 28th. So the Kejriwal is being accused of being a kingpin and a key conspirator in the Delhi excise scam. The ED said that in its remand application that he was involved in conspiracy to favor certain persons and also in demanding kickbacks from the liquor businessmen in exchange of those favors. He was involved in using the proceeds of the crime in the Goa election of the AAP, and that is the Aam Aadmi Party, of which he is the ultimate decision maker. This was said by the ED. Earlier in the supplementary complaint, the ED also alleged that Kejriwal spoke to one of the main accused, Samir Mahendru, on a video call and asked him to work with a co-accused Vijay Nair, whom Kejriwal called him his own boy, and Nair is a former communication charge of Aam Aadmi Party. Then the ED told the court that AAP is a beneficiary which exists as a company. Every person responsible for the conduct of the company is responsible. Apart from being liable as an individual, the CM is also liable, since Arvind Kejriwal is the national convener of the Aam Aadmi Party. He is responsible for its conduct. He controls the major activities of the party. According to ED, the Kejriwal was directly involved in the formulation of the excise policy of Delhi, which was drafted and considered to give favors to a group called as the South Group. Now, this so-called South Group is a group of individuals from South India that the ED claims secured uninhabited access and undue favors, attained stakes in the wholesale businesses and multiple retail zones, and paid ₹100 crore to Aam Aadmi Party leaders in return for those benefits. Two cases have been registered in relation to this excise policy, one by the CBI and the other by the Enforcement Directorate for Money Laundering. The case arose when a report was submitted by the Chief Secretary of Delhi, Naresh Kumar, to the Lieutenant Governor Vinay Kumar Saxena in 2022, pointing to alleged procedural lapses in the formulation of the Delhi excise policy of 2021 and 22. The policy came into force in November 21 and was scrapped in July 2022. The Chief Secretary Secretary report said arbitrary and unilateral decisions taken by Sisodia, who was then the excise minister, had resulted in financial losses to the Delhi exchequer estimated at 580 crore rupees. It was alleged that the kickbacks received by Aam Aadmi Party and the Aam Aadmi Party leaders from the owners and the operators of the alcohol business for preferential treatment such as discounts, extensions of the license fee, waiver on the penalties and relief due to disruptions caused during the COVID-19 were used to influence the assembly elections in Punjab and Goa in 2022. The report was referred to the CBI and Sisodia was arrested in February 2023. The ED alleged that the scam was to give wholesale liquor business to private entities and to fix a 12% margin for a 6% kickback in return. And it is the first prosecution complaint in November 2021. ED said the policy was formulated with deliberate loopholes that promoted cartel formation and brought backdoor benefits to Aam Aadmi Party leaders. Before his arrest, Kejriwal was issued a total of 9 summons, which he skipped and ignored as well. So these are. So the next most important question that was raised during this is, can Kejriwal continue to be the CM while he is in custody? So technically yes, because he's not convicted of an offence, he's just in the custody, but then there are various technicalities for him to run the government from a prison, and let's see what it is. Now questions are being raised about Delhi Chief Minister, whether he can continue to occupy the public office that demands high degree of morality, and also while he continues to be in the custody of the ED until March 28th. Judgments in the Supreme Court, High Court have previously concluded the constitutional morality, good governance and constitutional trust are the basic norms for holding the public office. A recent judgment by the Madras High Court in the S. Ramachandran versus Senthil Balaji referred to arguments made in the court with whether a minister must forfeit or his right to occupy a public office that demands a high degree of morality if he is accused of a financial scandal. And this was given in one Mr. Balaji, who was a former Tamil Nadu electricity minister, and he was arrested by the Enforcement Directorate on money laundering charges last year. He continued to be the state minister without a portfolio while he was in judicial custody. The arguments refer to a 2014 Constitution Bench judgment in Supreme Court in the Manoj Narula versus the Union of India, which has said that the basic norm for holding a public office was constitutional morality, that is to avoid in a manner that contradicts the rule of law, and the second norm was good governance, and the third was constitutional trust, that is upholding high degree of morality attached to the public office. There are practical difficulties, let me tell you, in running the government from when the CM is in custody or is in prison, as it may require summoning of officials or calling for documents which may have to be signed, but all these documents have to follow the jail or the prison rules before taking them inside. They might have to be scanned, which will lead to revealing of the state secrets. This is again the constitutional law, and also the office of the Prime Minister, where he upholds the secrecy. Apart from that, also the jail inmates have to follow certain rules of the jails, which is not possible for them to run a government from there. They have to follow the rules, and they're not allowed to meet many people as well. So these are some of the technical issues that will arise. On the other hand, there is the morality or the of running the business from a prison, where usually people who are convicted for wrongdoings are placed at. Kejriwal anyway does not suffer disqualification because he is not convicted. This is a pre-conviction custody that was happened is being taken place by the Enforcement Directorate. Therefore, he is not disqualified under any article of the Constitution or the Representation of People Act 1951 and does not face any disqualification as that. However, he could have appointed a successor, like the manner in which Lalu Prasad Yadav did previously, Jayalalitha did previously, and also Hemant Soren did previously. They appointed a successor before going to the jail. There is also another ground where So there is no bar on staying as a CM, but there are practical issues. Also, in case of the LG feels that because of Kejriwal's arrest and custody, that the governance of Delhi is being affected, then he can give a report to the President of India, and President's rule can be imposed. Apart from that, the President herself can take into account the situation of Delhi governance, and she can take over the governance of the Union Territory of Delhi, and the President's rule can be imposed for 1 year, extended every 6 months for 1 year at a time. And so this is about what are the technicalities involved. And the last and the final issue is with regard to vote for home for Lok Sabha elections. Now, as preparations for the celebration of democracy is underway, now the mammoth exercise requires a lot of voters that need to participate. and therefore in an effort to allow people with disabilities and also 85 and above to vote. Now the Election Commission of India has become with the to allow the people to vote from home, and who is eligible? People above 85 and above are eligible. People with disabilities, that is, disability shall not be less than 40% of the prescribed handicap and certified by a certifying authority. Apart from that, media persons covering polling day activities, they have to carry authorizing letters from the Election Commission of India. Workers from essential services like metros, railways, healthcare, and service voters like personnel of the armed forces posted away from their hometowns, Central Armed Police Forces deployed away from their home, and also on the poll duty. So what do they need to do for this? The key is that they have to take a form 12D, which is a letter informing the assistant returning officer that the person will not be able to go to the polling station, and the form can be downloaded online from the Election Commission of India website and collected from the office of the representative of district officer of the parliamentary constituency. Distribution of the form 12D has already started in the Tamil Nadu districts as the state heads to polls on April 19th. The form has to be filled and then submitted within 5 days of notification of the polling date, and this will then allow them to vote from home. So these are some of the most important polity and governance issues of the week. If you did, please do like, share, subscribe, and don't forget to comment at the end of the video, and I shall see you in my next post. Until then, it's very happy learning.